Hello, I'm Kimberley Davies and welcome back to the Candid Divorce Lawyer podcast. In our last episode, we were joined by barrister Helen Brander to discuss the alternative options to court processes. In today's episode, I'm joined by my colleague and family solicitor Kate Lewis, and we are going to discuss the immediate financial considerations, such as protecting assets and setting expectations following a separation. Kate, thank you for joining me today. I know we've been talking about and looking forward to this podcast for a while now, and I've had the pleasure of getting to know you for the last 2 years. But before we kick off, perhaps, Kate, you could tell our listeners a little bit about yourself and what led you to have a career in family law.
Hi, Kimberley. Thanks. It's great to be here and really looking forward to recording the episode today. I've been working in family law for about a decade now, advising clients in respect of all elements of relationship breakdown. In terms of how I came to become a family lawyer, a slightly alternative route, I suppose, in that I did a psychology undergraduate degree and then converted to law later on. But I think that naturally led quite nicely into a career in family law, and I can draw on my experience from that psychological understanding when I'm helping my clients in their family law situations.
As family lawyers, we help clients with financial decisions in various different ways. Obviously, day to day, we might be helping them negotiate a fair settlement or providing advice on how assets are maybe going to be divided. But I think for anyone starting out on this process, the first question they often want to know is, what are the first financial steps and what recommendations do we give when it comes to looking at the finances when the marriage ends initially?
I think you will always hear family lawyers talking about a full and frank financial disclosure. And it goes without saying that that is always a really important first step. It enables you and your ex to be on equal footing in terms of knowing what the assets are, what you need to be looking at moving forwards. And most importantly, it enables you both to take proper advice on what a fair solution might look like. No family lawyer is going to be able to give you some bespoke and detailed advice on what a fair financial settlement is going to look like without knowing exactly what the matrimonial assets are. I think there are some, aside from the exchange of financial disclosure, which will inevitably take a little bit of time to pull together. And it is important to try and get your sort of ducks in a row financially and understand what your assets are, the number of bank accounts that you've got, where your savings are held, and sort of start to gather that information for the purposes of the full and frank financial exchange. But there's also some other kind of more immediate steps that you can take if necessary, including getting an arrangement in place for interim finances. So looking at most immediately, how is the mortgage going to be paid each month once you're living separately, if one person's moved out of the property, for example?
And I think that's a question that we get asked so often, isn't it, in those first calls? People saying, who's responsible for the bills? Who's going to pay the mortgage, the utilities, car loan, kids' hobbies? The list just goes on. And I think in that stage, people are often almost in panic mode. They don't know what to do. So who is legally responsible for all of them?
I completely agree. It's such a concern for so many clients. The first thing they want to know is, how are these payments going to be made each month? When it comes to the law on this, interim arrangements can be quite tricky to navigate, and there's no hard and fast rule about it. The mortgage, in many cases, the property is held in joint names and the mortgage is therefore held by both partners, and they are both jointly and severally liable for making sure that payment is made each month. So we will often advise clients that the status quo should be maintained until a more permanent solution is put in place. So whoever has been responsible for meeting the mortgage payment historically should continue to do that. But ultimately, if one party fails to make the repayment, then the bank or commercial lender is going to look to either or both to make sure that the payments are covered each month. So it's a really important conversation to have early doors, and something that it's really important to speak to a family lawyer about so that they can put in place an interim arrangement. And I think that also gives you both some certainty about what the financial arrangements are going to look like over the next few months whilst you have a kind of more longer term discussion about financial separation. There's nothing more worrying to clients when they first come in to see me to say, well, my mortgage payment's going out in 3 days and I haven't got any money to cover it. So that's really crucial.
And I think the other thing that I often get asked is about what will happen if one partner clears out a joint bank account, or they're going to take all of these assets and sell them. Are there any legal protections to deal with that worry?
Yeah, absolutely. That is a concern, and especially if there are significant sort of cash capital savings in a joint bank account. Joint bank accounts, by their nature, both parties usually will have the ability to make deposits and withdrawals from those accounts, and there's nothing that would stop them from sort of unilaterally withdrawing a significant sum. What I always advise clients is that if they're going through a separation and they're worried about access to joint accounts, it's worth speaking to your bank, speaking to your account manager or somebody within the bank to explain the situation and what protections and measures they would suggest are put in place. It's quite commonplace for a restriction on a withdrawal over a certain amount without joint authority. And it's also worth thinking about overdraft facilities as well if you're concerned about debts. And you want to make sure that your ex can't sort of max out an overdraft, which you're then ultimately on the hook for as a joint account holder. So speaking to the bank to put restrictions on or cancel the overdraft facility can be a really useful first step as well.
That's a really good tip. And the other one I often talk to clients about is credit cards. I think we forget that they're usually in one person's name, but often within a relationship, the other person has a second card to it. And unfortunately, we've seen those incidences where one person has run up a credit card bill. So it's just, I think, keeping on top of all of that and perhaps shutting down the second card holder or reducing limits just so that you can't find yourself in a sticky situation later down the line.
Yeah, definitely. Debts can be equally as difficult to manage moving forwards as assets. So really important.
So far, we've just assumed that they're living together and both names are on the property title or the lease if they're in a rental property. What can people do if they're actually living in a home where they're not the legal owner or on the lease?
So I think it's really important for our listeners to understand that even if the family home is held by one partner, that doesn't mean that they can exclude the person who's not a legal owner of the property from the property. As a spouse, if you're married to the owner, you have a legal right to occupy the property. And what you can do is register what's called a home rights notice with the Land Registry, and that will just alert any person that's looking at the legal title document to the fact that you have a right to occupy the property, and it means that the owner can't sell or deal with, so they couldn't take a second mortgage out, for example, on the property without you knowing about it. One thing that I always make sure clients are aware of is that if they are registering that home rights notice with the Land Registry, it's probably worth giving their partner the heads up, because they will get notified by the Land Registry directly once that notice has been put on the title. And it's always just a bit softer if it comes either from the partner or from their solicitor with a letter just explaining why they've taken that step and the reasons they've done it to protect themselves.
And I think it's just to give that reassurance, isn't it, that it's not necessarily an aggressive step. It's just to make sure that everyone knows where they stand,
Exactly.
Whereas actually getting formal paperwork can be pretty intimidating otherwise.
Exactly, yeah.
So that just assumes that they want to live together. And again, you and I, in our experience, we speak to so many clients that when they're going through a separation, they don't want to live together, they can't live together. One question I often get asked is whether or not they can force their ex out of the home. What would you say to that?
It's such a common question. I think the relationship has broken down, emotions are still really raw, and the idea of having to share the same space is just so unimaginably difficult. I think the law on this point isn't particularly helpful to clients going through that situation. As a legal owner of the property, you would both have the same right to occupy the property. And it's very, very difficult to secure an order. It's called an occupation order from the family court, which basically excludes one legal owner from the property. The court, if they were looking at making such an order, they have to undertake what's called a balance of harm test. And the threshold for getting that order is very high. perhaps understandably, given that somebody has a legal right to occupy a property, so why shouldn't they be entitled to stay there? And for that reason, lots of clients find themselves in a situation where they are having to continue to co-occupy a property whilst these negotiations are ongoing and a sort of more long-term solution is put in place. And that can be quite difficult. There needs to be a mutual level of respect and, cooperation about how they're going to share that space. But unfortunately, it's very difficult to remove somebody from the property.
Okay, so moving on a little bit from that immediate aftermath and working out an interim arrangement, how are assets generally viewed by the court and how are they divided if there's no clear legal agreement in place? Obviously, nowadays we are seeing people coming to us that do have prenups in place that actually determine and explain what the agreement is between the couple if their marriage does break down. But obviously we've got jointly owned assets, we've got assets in sole names. Do you mind just giving our listeners a little bit of an overview as to how they're treated?
Yeah, sure. So I think coming back to the first point that we made about full and frank financial disclosure, the first exercise is going to be a computation of what the assets are. So looking at what property there is, what savings, capital investments, shareholdings there might be, any cars or personal belongings that are of significant value, and looking at what the matrimonial assets are in the round. And then once you've worked out how much is sort of in the pot and available for division, the court then applies a series of factors to look at what a fair financial outcome is going to look like. The starting point for that is going to be equality, and you'll often hear family lawyers talk about that, which would be, an equal division of the matrimonial assets. But there is one, very significant caveat to that starting point, and that is on the basis of needs. And the vast majority of cases, big money cases aside, where there's plenty of money to go around, the vast majority of cases that we see are going to be what are called needs-based cases. And the court has to make an assessment of what the parties need to meet their housing needs, most importantly moving forwards, and particularly the needs of any minor children, and then distribute the matrimonial assets to account for that.
And I think it's probably worth highlighting that we use this marker of fairness. And in our day jobs, we're acutely aware that everyone's perception of fairness is very, very different. Yeah. And so it can be really tricky. And also, everyone that we meet generally has a friend or someone at the school playground or a family member that's been through a divorce. And I think you'll probably agree with me that we get told stories every week that that's not fair because so-and-so got X and so-and-so got Y, which is why I would say it's always so important to get that legal advice quite early on so that it's bespoke to your situation, because there is no rule book, there is no online calculator that family lawyers all secretly go to work out what a fair division is. It's completely bespoke on the circumstances of your living arrangements, your asset base and your family.
Yeah, absolutely. I think every case turns on its own facts, and that's why playground or down the pub advice is so dangerous, and actually speaking to a professional early on and getting a real clear steer on what you might be looking at in terms of a fair settlement in your situation is so important.
And I think the other factor that's probably worth talking about today is that for some of the people that we meet, they've never been in charge of the finances before, and that isn't necessarily a negative. Families have different roles, different dynamics, and when they're together, it may work very, very well. But often we do come across people that not only are feeling quite overwhelmed and vulnerable because they're going through a relationship breakdown, but also because they suddenly find themselves in charge of finances, which they've never had to manage before. What's your advice for someone in that situation?
Yeah, I think that's actually more common than people might tend to believe, particularly where there's been sort of a more traditional marriage where, the different partners have taken on very different roles. And it can be really terrifying for clients who are suddenly responsible for managing their outgoings each month, their costs, bringing in an income, whether that's earned income or from, maintenance, child maintenance, universal credit, and then making that work for them on a month-to-month basis is really daunting. So I think it's really important, firstly, to be very careful and considered when you're preparing your budget, looking at what your essential costs are every month and how you are going to meet those, and then what money is left over and how you're going to apply that. I would really encourage clients in that situation to take some advice as well from a financial advisor. We often advocate for collaborative working practice and working with other professionals to make sure that the client feels fully supported, and working with somebody that can do some budgeting or some cash flow modelling to demonstrate to a client what their financial settlement is looking like for them and how they can make that work for them, not just in the immediate future, but moving forwards for their long-term financial health, then that can be really, really valuable.
And you've touched upon working collaboratively then. And my next question, I can probably half guess what your answer may be, is we talked about feeling overwhelmed and vulnerable. And then we're also expecting people to make legal and financial decisions during that time. So how would you suggest people do navigate these tricky decisions about their finances when they're already feeling emotionally overwhelmed?
It can be such a difficult time. There's so much going on, and I think clients feel so overwhelmed. So it's really important to have a great support network around you. And I think that support network can include friends and family. Friends and family can be incredibly valuable and really supportive, and a really important influence over you at that time. And I always encourage clients to maybe bring a close friend or a family member with them to a first meeting, because a second pair of ears is always so helpful. So much information is going to be exchanged in that meeting, and it's often, a lot of it just falls by the wayside because it's information overload. So having somebody else there to help pick up on things is really valuable. But also then working with the more professional therapeutic side of things, looking to engage maybe a divorce coach or a counsellor or somebody that can help you work through the emotional side of the relationship breakdown. That's going to be really helpful for you in giving you the tools that you need to manage your thoughts and feelings. Also especially helpful where you've got an ongoing co-parenting relationship with your ex, making sure that that works for you and most importantly works for the children. And it also means then that when you are spending time with your lawyer, who's probably quite expensive, you're really limiting that conversation to the important legal aspects of your separation and issues that the lawyer can actually help you with, rather than distracting those important discussions with more emotional issues.
I think that's really good advice. Obviously, again, doing this work for some time, there are some common mistakes that we see people make. What would you say are 1, 2, however many you've got, sort of legal mistakes that we see people make early on that could perhaps be avoided?
I think something that I've seen quite a lot is immediately on separation, maybe one partner makes real knee-jerk reactions to the situation. So perhaps they've moved out of the property and they just immediately cancel all of their direct debits. The mortgage goes unpaid for a month or something like that. And it's really unhelpful, not only because it sets things off on completely the wrong footing. Ideally, you want to work together to come to a resolution with your ex. So you need to keep a channel of communication open and you need to keep that trust and respect there. And when the person that's left in the property with all of the bills going unpaid finds himself in an incredibly vulnerable situation, that just sets a hair running. And I think it really sets things off in the wrong way. Mm-hmm. So I would always say, think about it before you act, make considered decisions for the family as a whole particularly at that real crucial point where it's a real change for the family.
I entirely agree. And I think people can be tempted to just rush into everything at that stage. And I have a lot of empathy for that. It's suddenly a turbulent time. And as people, most of us feel a bit more comfortable when we've got some certainty. Yeah. But it's a difficult time. And I think that needs to be recognised. And actually, if people need a couple more weeks, if they need a month, 2 months, whatever it may be, that's fine. There is no reason to rush these decisions. Yeah. They are big decisions. And people generally don't rush into huge decisions in any other element of their life. And they certainly shouldn't on separation.
Yeah, exactly.
What advice would you give to someone then, if they're listening, perhaps in the early days of a separation? What would that initial advice be as to the things they should be thinking about, perhaps the documents they should be getting ready to help with their lawyer at the moment?
I think taking some early advice from a solicitor is really helpful, even if you don't necessarily feel ready to act on that advice straight away. Speaking to somebody who has the legal expertise to guide you through what your options are. I think it's really important to find there's lots of different ways of sorting out a financial settlement and coming to an agreement, and having somebody that's going to set out for you the options so that you can make an informed decision about what process is right for you is really important. So speaking to somebody and taking that advice early on, and then having the opportunity and the time to digest it before acting, as you've just sort of spoken about. And then it's just starting to sort of gather a picture of the financial picture as you are aware of it. And it might be a situation where your ex has, not been particularly transparent during the marriage, and you don't necessarily know what their assets are. But what you can do is what's within your power, start to gather your bank statements, any documents that you do have about life insurance policies, pension information. Pensions can often be quite slow to respond to requests for valuation. So getting the ball moving on those kinds of information gathering exercises can be really helpful, just to start to get your ducks in a row. So when it comes to collating all of that information with your family lawyer for the purposes of full and frank financial disclosure, it's not such an uphill battle.
I think some of my clients often find it quite empowering as well, actually, especially if they feel very vulnerable, very overwhelmed. Actually just starting to gather that information, it just gives them a bit of clarity, and that can be really important at that time.
Yeah, definitely. And taking it slowly, like bit by bit. When somebody sends you a Form E to look at and says, complete this, I can imagine it's quite overwhelming. It's a pretty long and difficult document to get your head around. I would hate to complete one, and I'm sure you would too. So taking it section by section and just taking your time with it, is a really good way to tackle it.
I know it's a cliche, but I've heard all of us in the office saying to our clients that ultimately this is a marathon, not a sprint, and just taking those baby steps are really important, and just making sure you're being kind to yourself whilst doing that. It might be completely alien to gather all of this stuff, but just taking baby steps is really useful. And that wraps up today's episode of the Candid Divorce Lawyer podcast, where we tackled the first financial steps, looking at who pays the bills, what happens to assets, and just generally all the things that you can do to perhaps make yourself feel a bit less overwhelmed during that separation. And I think that final tip is really, really important, that clarity and planning and taking things slow really are your best allies. If you found today's discussion helpful, be sure to subscribe and leave us a review. In our next episode, we're shifting gears and diving into a crucial topic: navigating children matters, the living arrangements and co-parenting life. We'll explore what a court would consider, how you can put your child's well-being first, and some practical tips for building a workable co-parenting plan. Until then, thank you for listening, and we look forward to talking to you again soon.